There was some big news in the data privacy world this week, especially for those of us on either side of the Atlantic. The European Commission finally adopted the proposed EU-US data privacy framework. The framework will make it easier for American companies to do business in the European Union and vice versa. So what is it? Well, by way of background, data privacy in the EU is regulated under a supranational law known as the General Data Protection Regulation, or GDPR. The GDPR sets forth the requirements on how all organizations, whether they're based in Europe or not, must handle the data of EU citizens. The GDPR heavily restricts organizations from transferring the data of EU citizens outside the borders of the EU. Under the GDPR, the European Commission issues what it calls adequacy decisions. An adequacy decision is a country-specific determination that a particular non-EU country offers an adequate level of data protection for the data of EU citizens to be transferred there without violating the GDPR. Previously, the EU had issued an adequacy decision for the United States as part of what was called the EU-US Privacy Shield program. However, in 2020, the European Court of Justice struck down that program in a case that became known as Schrems II, after the Austrian data privacy activist who brought it, Max Schrems. Since then, the only valid means available under the GDPR for transfers of EU citizen data to the US were standard contractual clauses, or SCCs, or binding corporate rules, BCRs. SCCs are for transfers between organizations, whereas BCRs are for intra-organization transfers. Executing, implementing, and adhering to SCCs and BCRs was a colossal headache, especially for American companies that have operations in Europe. So what happened this week is that the Commission issued an adequacy decision for the US based on commitments made by the US government under the framework. That closes the compliance gap that opened when the Privacy Shield program was struck down. There are two words of caution I want to put out there, however. The first is that eligibility for transferring data under the framework is not automatic. American organizations have to apply for certification by the U.S. Department of Commerce, which administers the program in the U.S. Until it's certified, an organization still has to rely on SCCs and BCRs. Failing to comply can get a U.S. company in trouble, not just in Europe, but in the U.S. as well, as compliance by American organizations is monitored and enforced by the Federal Trade Commission. The second is that the Privacy Framework Program is not without controversy in Europe. The Commission adopted the framework over the objection of the European Parliament, which passed a non-binding resolution opposing it in May. That gives Max Schrems, who has also opposed the framework, ammunition to mount another legal challenge. So stay tuned. Thanks for watching Kilobytes. For more, follow us on LinkedIn, Medium, and YouTube. I'm Sabri Ibrahim of OptimEdge Legal.